Well, hi, everyone. I'm David Glazer, and I am just here to introduce a couple of my colleagues and launch us right now. So our topic today is immigration. We'll come to that in 1 second. Our very quick ministerial points. First, next month's webinar, which will be on March 8th, another one of our colleagues, Steve Helland, is going to talk about website accessibility, which is a really big issue. We're getting lots of litigation about it and letters of complaint. And I think we're going to work in some stuff about 1557. I believe that Marguerite Amen will be on, but where that's to be determined. But the one thing that's certain, it's March 8th. You'll get an email about it. You're always free to ask questions during the webinar. Lon and Bob are happy to answer them. You can type those questions in the chat box. Access the chat box by raising your mouse to the middle of the page. The little arrow comes down and you can get it that way. If your sound through the computers slows down, we have limited control. You know, the internet sometimes slows down over the lunch hour. It has to take, even the internet has to eat. You can always dial in, and that number is in the chat box. So without further ado, I'm going to just do a very short introduction of Bob Aronson and Lon Wynn, who are immigration colleagues. They Bob has only been here for what, 3 years now or something like that?
No, year and a half.
Okay. Lon, far longer. I am lucky to work with the two of them. One of the things that's kind of amazing, they have, I think, worked with people in every state. So to help people immigrate with healthcare organizations, other things too, but healthcare is a lot of the work that they do. And so it's kind of cool to have someone who's done work in every state. I will basically now shut up and let you guys take it away. I think, Bob, you're starting us off, right?
Yeah, thanks, David. Thanks. And hi, everybody. This is kind of exciting times on two levels, and hopefully we're going to be addressing both. Number one, healthcare and access to physicians, and number two, the intersection of physician recruitment with immigration, which is certainly occupying the front page of our national experience these days. So here's what we want to do. What we want to do, this is not simply a talk about immigration or talk about IMG immigration. What we want to do is explore how you can make immigration work for you, how it can make IMG recruitment giving you a competitive edge. What some of our thoughts are on how to weave in the immigration narrative so as to position your organization to better and more aggressively recruit IMGs. So if you've got to go through the immigration process, get as much bang for your buck in terms of not only technically looking at immigration, but also making it into part of the recruitment pitch. So here's what we hope to do. We've got three objectives from this program. Number one, we do want to go over some of the skill building aspects of physician immigration. We're going to be talking about J1 waivers. We're going to be talking about H1Bs. Few words about permanent residence. That is the basic things substantively you need to know when you're looking at the IMG market. Number two, and I think probably what's kind of the unique aspect of this program is given that you've got to address the substantive aspects, how can you make this, weave it into your immigration, your recruitment pitch? So how can you make immigration really work to distinguish you and give you a competitive edge when recruiting, as well as retaining physicians? And number three, I think we'd be really disingenuous if we didn't talk just for a moment about what is the overall general situation in our immigration program today. And certainly over the past 2 weeks, we've received an absolute flood of calls and emails from IMGs, from medical systems, saying, what does all this mean? So let's just talk for just 1 minute about really the elephant in the room. That is, what is going on? And I think we need to break it down into three components. Number one, what exactly happened? Essentially, a week ago on Friday, that is the 27th of January, President Trump announced a revision to our immigration system that affected certain countries, which kind of created a certain tone of severe restriction, and it also suspended actually our refugee program. So that was kind of the initial approach, which said which really kind of made an announcement that there was going to be kind of some major new revisions to immigration coming out of the executive office. Over the last 10 days, there have been quite a number of revisions, some of it coming out of the court system, some of it through reanalysis within the administration itself, a little bit from the Congress. There's certainly been a lot of public outcry. There was a major suit initially filed in the state of Washington, actually to which the state of Minnesota was a co-plaintiff, which is now in the Ninth Circuit Court of Appeals, which at least as of today rolled back the executive order. So as things stand today, and this is certainly subject to change, the executive order has been rolled back. Individuals can get visas, can come to the United States. There's been no ostensible change. In terms of what's going to happen in the future, my own expectation is that we will continue to see the ability of foreign nationals across the board to get visas to work in the United States. There's been a great deal of publicity on and news on the contributions of physicians in terms of serving minority populations and providing gap-filling services, on the need of the U.S. healthcare system to incorporate IMGs into the health delivery system. But again, I would be grossly wrong in saying definitively this is what can happen. And actually, we do expect to get a decision by the end of the week on the continuing existence of the executive order. But it is something to be aware of, and to the extent that we can predict, the things that we're going to be talking about today, in substance, will continue to exist. Okay. So both separate and aside from what's coming in the future, there are some changes which we do anticipate. First of all, we do think that within any type of revision to immigration, there's going to be some sensitivity to what are the needs within the business community. I mean, the president is a product of that community. Certainly, segments of the business community have become quite vocal in terms of expressing the role, the contributions of foreign nationals to business success. There is one thing which we may see, and if that's the case, we hope to come back to this forum and give some updates on reforms to the H-1B temporary worker program, and that could be problematic. But again, let's just hold that for the time being. What we do see, and this is something that Lon has been particularly active in, is worksite enforcement. That is, making sure that your organization is compliant with the law, is documented in terms of their compliance, because we do see that there may be some a return to a very strict enforcement policy. When you take a look at immigration and IMG, it certainly does not take place in a vacuum. So, the demand for physicians in general, the role of IMGs are certainly going to be tied in with healthcare reform. What's going to be the continuing need for physicians, the demand within the marketplace? How does that get served? Obviously, all of that impacts really the basic building block of IMG immigration, which is supply and demand. The whole notion is that IMGs constitute about 24% of the physician workforce. There's a significant untapped market, and so the issue becomes, what's the need of the market to recruit and incorporate IMGs into the healthcare system? So one of the things that is certainly emerging, which I had spoken to a little bit in the past, is that IMGs really do provide gap-filling services in terms of the healthcare system. They tend to go into medically underserved areas. They're disproportionately present within primary care. They tend to serve ethnic populations, large of their own ethnicity, in a manner that surpasses possibly their U.S. counterparts. So there's more and more data that seems to be developing on the positive contributions of IMGs that in turn provide some basis for feeling that there will continue to be a significant role for IMGs in the healthcare system. So, question becomes, what's going on in healthcare staffing and where does immigration fit in? Let me just take 1 second to define terms. International medical graduate is simply a physician who has taken his or her medical education abroad. That is the essential notion, the essential definition of an IMG. So it could be a U.S. citizen, it could be a permanent resident, or it could be a foreign national having visa issues. And then the next question becomes, why even consider international physicians? What do they bring? Well, first of all, in the current healthcare system, in the current physician workforce, there are shortages in physicians. So IMGs become a non-traditional physician provider source. There are, again, 24% of all medical residents, of all medical trainees, are IMGs. Not all of them are going to require visa sponsorship. Lon's going to talk about that a little bit later. But there's a cohort, a portion of the IMG community that requires visa sponsorship. And our basic thesis, our basic belief is that your ability to manage and steer that process, to use your ability, your system's ability to sponsor for visa status IMGs becomes a very important component in terms of your overall staffing abilities, your success in staffing, and in turn it suggests how you want to weave in immigration into your recruitment pattern. And so, again, all of the data seems to indicate that IMGs provide gap-filling services. They do it on geography, going into medically underserved areas, rural areas. They do it in practice specialty, in particular primary care, and they disproportionately serve patients as safety net providers. Okay. Obviously, we feel very comfortable with immigration, but we'd be quite disingenuous in saying that there aren't some disincentives. So what are those disincentives? Number one, the time required, the additional time to go through the recruitment process as part of a recruitment. The additional expense, working with attorneys. Hate to say it, but that is probably a disincentive because IMG recruitment certainly takes recruiters, takes systems out of their normal comfort zone. There are certain concerns with the cultural and linguistic adaptability of IMGs to serving the market. Certainly needs to be explored. Employers also feel that there may be concerns with what's the duration of the IMG's commitment to the system. Is the system going to go through the sponsorship process, the expense, the time, the effort, and have the IMG skip out? I would say that that issue, pursuant to studies conducted by the General Accounting Office, seems to indicate that IMGs have more commitments, particularly to medically underserved areas, than is the case for their U.S. counterparts. In terms of clinical capabilities, when years ago the test capabilities, the medical competency capabilities of IMGs were below their U.S. counterparts. Now the test results seem to indicate exact parity between IMGs and their U.S. counterparts. And of course, there's always the complexity of the U.S. immigration process. Here are just a couple suggestions on what you might want to do in order to best position your system to go after IMG recruits. First of all, we always see our own role, and I think you should expect this from your immigration attorney, as part of your recruitment team. So as you're discussing possible recruitment or employment opportunities with your IMG candidates, bring in your immigration attorney. Have them speak with your recruit. Number one, it conveys a certain seriousness and commitment of your organization to their immigration welfare. Number two, it lets you very early in the cycle troubleshoot to get a sense of what are the challenges as well as the timeline in the immigration. And I will absolutely guarantee that if you get your recruit talking with your immigration attorney early in the recruitment cycle, you're going to be making a major step forward in distinguishing your organization as being a desirable landing spot for that IMG. Obviously, with any type of recruitment, you have to understand the objectives of the physician candidate. So with an IMG, what is it? Number one, like any other candidate, they want a good job. Number two, they want to have a stable immigration. They want to have an employer that is committed to their immigration welfare. And that's exactly where addressing their immigration needs up front at the beginning becomes very desirable. So in addition, as you're speaking with IMGs, it is very desirable for you to address their spousal needs. In many aspects of immigration, employment authorization is granted to the principal foreign national, the physician, and the spouse may or may not have employment authorization. So in particular, if a placement is being made in a rural community, you want to have some sense and convey some interest in the welfare of the spouse. What can they do? How can they make their stay in the United States enriching and growing? So explore that, because it also impacts a great deal on retention issues. It is also an IMG, generally speaking, will want some type of roadmap leading to permanent residence. And you can really build in the permanent resident process, the whole sponsorship, the time required to qualify a physician for permanent residence, in terms of not only addressing their needs for permanent residence, but also using permanent residence as one additional hook for long-term retention, because it takes a long time to get permanent residence, and in many instances, the physician is going to have to remain employed with the sponsoring employer until he or she gets permanent residence. And it would make sense, particularly if you have a certain volume of IMG candidates or IMG employees, to have some type of corporate immigration policy addressing things like who pays, when do you start the permanent resident process, what are the policies for dependents, for spouses, for children, and what's the overall expectations. Simply having a policy, again, it's one of the distinguishing characteristics which makes your system both unique and highly competitive. So with that broad brush background in terms of some of the ways in which recruitment can be integrated into a recruitment program, let's turn somewhat to what in substance are we talking about, and what do you need to know when you're looking at an IMG candidate. Juan?
Thank you so much, Bob. I cannot agree with you more in regards to the strategy memo that you mentioned that is required to really help lay out the roadmap for your IMG and also your internal team who will be supporting the IMG and their needs when they are employed with you. We're going to look at the three options that are available or that is often discussed in the strategy and the strategic considerations of IMGs when employers are asked to sponsor them for certain types of work visas or lawful permanent resident options. In determining what your options are available to you and the IMG, you have to look at what is their current immigration status. Your IMG may come to you as a J1 exchange visitor, or he or she may be an H-1B temporary worker. And there are different considerations that you need to discuss with the IMG and also discuss with legal counsel in determining what is the best strategy to have them join you and have a seamless transition. Immigration is a very complex process, and it's really important to have the roadmap laid out clearly for all the parties before you proceed or before they join you, is to have a clear idea and picture of what will happen. You also have to consider what is the long-term goal of your IMG who you may be recruiting or having discussions with in joining you. Are they interested in lawful permanent resident status, which is the green card process? Is this a long-term relationship that you want to invest with your IMG? And what are the options to the IMG to obtain lawful permanent residence? There are certain requirements depending on what their visa status is currently or will be. And so we are going to first focus now on the J1 exchange visitor visa. Most IMGs are in J1 exchange visitor status. The J1 is intended to foster international exchange. So those individuals who are in the J1 exchange visitor programs are usually in fellowships or education programs to further their medical graduate studies. Now, when they are in the J1 status, there are certain requirements, though, that they have to meet in order to change their status. But let's look at the J1 exchange visitor candidate whom you may see when you are recruiting. The J1 is a temporary non-immigrant visa, so they will need visa sponsorship in order to work with you. They are also subject to a 2-year residency requirement, though. Foreign medical graduates are subject, no matter what country they're from, if they enter the U.S. in J1 status, or they're in the U.S. in J1 status to pursue graduate medical studies, they are subject to the 2-year residency requirement, which requires them to return to their home before they can obtain any other immigration status. And we're going to talk about, of course, waiver options that may be available to these IMGs if they are subject to the 2-year residency requirement. But that is a characteristic that you will have to address when you look at the options available in hiring these IMGs who are in J1 status. They are usually in J1 status for up to 7 years, meaning that they could be in a fellowship program that could be less than 7 years, but the maximum amount generally is 7 years unless there are extenuating circumstances. There are individuals who may want to engage in studies beyond the 7-year period because they have a subspecialty that they want to pursue further studies in, and that is allowed. But mostly it's up to a 7-year duration period in which an individual can be in J1 status. Also, regarding what they're limited in doing, for J1 visitors who are IMGs, they are limited in regards to the training activities, meaning that they must be engaged in training activities related to their medical studies, and there are other employment restrictions too that they may face as part of the J1 process. In order to be in J1 status, they must be sponsored by ECFMG, which is the organization responsible for the administration of the J1 program for IMGs in the United States. So let's talk about the 2-year residency obligations. What that means is that J1 candidates who come to you who are IMGs, they cannot change their status while they're in the United States to another work visa status. They also cannot apply for lawful permanent residence. We've seen situations where you have a physician who is fortunate enough to meet a spouse in the United States who might be a U.S. citizen, and normally under the immigration process, the U.S. citizen spouse can sponsor the foreign national, and the foreign national can change their status or apply for adjustment of status to that of a lawful permanent resident. Well, if they're a J1 physician, they would not be able to undergo the process of applying for the green card pursuant to the marriage because of their 2-year residency requirements. And so the options that they have is, of course, to get a waiver. There are many types of waiver. Actually, there aren't that many types of waiver. There are a limited number of waivers or types of waivers, and Bob is going to be discussing that with you. But they also can return to their home country for 2 years. What does that mean in terms of return to home country for 2 years? One question that we get a lot is if an individual is, for example, from China, but they lived in the UK prior to coming to the United States, do they have to go back to their last home place of residence, which was the UK or China? And so the discussion that basically the answer is that they have to go home to their country of foreign nationality, and that is where they have to serve out their 2-year residence unless they're able to get a waiver. There are other options, which is, for example, some J1 physicians, for example, I got a call yesterday from a J1 physician who is not going to be completing her fellowship program. So we were looking at various options, and one of them was that she was interested in changing her status to F1 status. And that is allowed, but we talked about whether it would be in her best interest to go ahead and get the I-20 and then go and get the visa abroad and re-enter in F1 status instead of changing her status to that of an F1 visa. Another option that J1 physicians also have is if they're a person of extraordinary ability, and that is a very high standard for physicians or individuals who are doing research. If they want to change their status or work for an employer in O1 status, they can obtain a O1 petition, approved O1 petition, but they have to leave the United States and apply for the O1 visa and re-enter the U.S. in order to work under the O1. So as you can see, the 2-year residency requirement is pretty unforgiving, and many physicians plan ahead as they're going through their fellowship. We have some very strategic and smart IMGs who contact us much earlier than 1 year before the end of their fellowship to determine what are their options and what are the waivers available as they're looking at potential employers after their fellowship is over. And Bob, you're going to talk about those waiver options that are available for the 2-year residency.
Yeah, so let's try to contextualize this. You've gone out, you've been recruiting for a position in your organization, and you've got some trainee engaged in either a medical residency or a clinical fellowship who you and your system really like. And it turns out that this physician is a J1. So as Lon said, every single J1, regardless of country of citizenship or country of last residence, is subject to the 2-year home residence obligation. So this 2-year home residence obligation applies to the physician from India and Bangladesh and the developing world, as well as to Canadians and individuals from Western Europe. So it's an across the board. And the first thing you're going to need to do, the very first thing, in all likelihood, is to figure out, can you get this person a waiver? And there are only 3 ways to get a waiver. One is called exceptional hardship. So if the physician has what's known as an anchor relative, that is a U.S. citizen or permanent resident, spouse or child, and if that anchor relative will suffer from exceptional hardship if the J1 goes back to his or her home country, then that would be one way to get a waiver. Couple comments. Number one, this doesn't require your sponsorship. It requires your awareness of the possibility of getting a waiver, but you don't sponsor this. This is something that the physician and the physician's family pursues. And in general, this type of waiver is applicable to physicians from either war-torn countries where there's a lot of anti-American sentiment, where it's an unstable and threatening situation, or where there are health needs that cannot be served in the home country. So we have found that the U.S. government is very receptive to claims of medical needs as creating the basis for hardship. Number two, if a physician will suffer from persecution back in his or her home country, then the physician, whether or not he or she has a family member, but simply by virtue of the persecution he or she may experience in going home, that would lead to the U.S. government issuing a waiver that in turn would let the physician remain in the United States. Again, that's going to be very fact-driven and restricted to only certain countries that are experiencing policies that directly threaten individuals based on religion or social class or related considerations. The third way to get a waiver is if a government agency steps in and overrides the 2-year home residence obligation. And statistically, this is how nearly all physicians get waivers. I mean, we're talking about 90 to 95% of all physicians tend to get waivers when they can demonstrate to a government agency, a U.S. government or a state government agency, that it is desirable, highly desirable for this physician to stay in the United States. Now, what's missing from basis for getting a waiver? It's an expression of release by the home country. So even if the IMG's home country says, we don't care if the physician comes back, that under U.S. law is not a basis for getting a waiver. So literally, the waivers can only be granted by exceptional hardship to the anchor relative, persecution, or the sponsorship of a government agency. So the question burning on everyone's mind is, why would a government agency override an IMG's return to their home country? Well, the law creates a standard, and it's called serving the public interest. So essentially, the law says that if a government agency, an authorized government agency, feels that the IMG is bringing to the table or bringing to this country services and will be working in a situation that will serve the public interest, that becomes the essential standard for issuing a waiver. And essentially what that means is expanding the safety net treating medically underserved Americans, and things like that. So, what are the paradigms for a government agency stepping in and overriding the To Your Home residence obligation? Well, basically, there are 4 situations leading a government agency to intervene and override the To Your Home residence obligation. Number 1, which is of limited applicability, I think, to this audience, but I just want to get on the table, is physician scientists. So if a physician is performing cutting-edge research of national significance, investigating new cancer treatments or new genomic approaches to addressing certain diseases, then a sponsoring employer could file a waiver application essentially to the NIH saying, grant the waiver because the United States and humanity as a whole will be better served if the physician stays in the United States. So that is generally, although not exclusively, but generally a type of waiver that academic institutions would pursue. Number 2, if an IMG gets a job offer directly from a U.S. government employer, that would be a basis for getting a waiver. So that's mainly the VA physician. Department of Veterans Affairs recruits an IMG, and in order to serve their patients, in order to best discharge their mandate, they could sponsor the IMG for a waiver. So that would be number 2. Number 3 is certain federal agencies have programs to step in and override the To Your Home residence obligation. So the Department of Health and Human Services out of Washington will in certain instances sponsor IMGs, but they're limited under their own regulations solely to primary care physicians. And then there are certain regional government agencies, the Appalachian Regional Commission that handles social and economic development in the Appalachian region, for the Delta Regional Commission, the DRC, Delta Regional Agency, DRA, which does the same thing in a limited geographic area of the Delta region. They see the incorporation of physicians as being necessary for economic and social development within their geographies. They also maintain waiver programs. But far and away, the most popular, the most active waiver theory is conducted through the state departments of health. So, and that's the Conrad State 30 waiver program. So essentially, and this dates back to 1994, Congress passed a law signed by the president that gave each state, or gives each state, a limited number of waivers that they can use in order to sponsor physicians who are doing meritorious work. So that's what I want to talk about, just a little bit about the Conrad program. What is it? How can it work for you? What do you need to do? So the Conrad 30 program was created by federal legislation. And the federal legislation basically lays out a few broad parameters. It says that each state can sponsor up to 30 physicians each fiscal year for waivers, override the To Your Home residence obligation. Of that 30 waivers, 10 can be used in non-medically underserved placements, and the balance of waivers can only be used in designated medically underserved areas. So that would be medically underserved areas, or HPSAs, health professional shortage areas. That is, areas that have been designated by the federal government as having a shortage of physicians. And the program essentially opens every October 1st, and it's at that point in time that employers could file waivers. And again, the underlying objective is to show that if the waiver is granted, the physician will be expanding the safety net for medically vulnerable populations within the state. to address a popular misnomer about the program, Conrad waivers can be used for either primary care or specialty care physicians. It's up to the state. Some states do restrict things solely to primary care, California, for example, but most states will grant waivers for specialty care physicians. Here's the thing which I think you really want to be aware of when considering a Conrad program. The federal law lays out certain basic parameters. It's really 30 waivers. It says that if you get a waiver, you've got to work 3 years in H-1B status. It says that the program opens every October 1st. Just a couple basic parameters. Then each state moves in and sets certain additional criteria, things they want to see in the contract, primary care versus specialty care waivers, if they'll do flex, and so on. So you need to have an awareness of the state in terms of their substantive provisions, and you also need to be aware of what's going to be the demand on the waiver numbers. Because remember, there are only 30 waivers for each state. So certain states really use up their waiver numbers quite quickly. Others may have waiver numbers existing for most of the fiscal year or maybe even the entire fiscal year. But what this says is if you're in a high demand state where the numbers go very quickly, you've got to make your decisions on your IMG candidates usually by around August, because it becomes incumbent on filing your waiver October 1. So it does distort your decision-making and your interview process, but again, that's going to be a function of the availability of waiver numbers within a state. So you need to either pay attention to what the state is requiring, both substantively in terms of what do they require and what are the expected drawdowns of the waiver numbers, or get appropriate legal counsel in terms of guiding you through this process. But in any case, whether it's a high or low demand waiver state, the underlying policy, and you need to be aware of this and document, set forth, and keep this objective further in mind, is that the underlying policy leading a state to intervene and override the two-year home residence obligation is if you can show that your recruitment of the J1 physician will increase the safety net provided to medically vulnerable patient populations within the state. That's the key area you're trying to establish. Okay, so you've got your J1 candidate, you've gone through the J1 waiver process. What then? Well, if the waiver is granted, under law, the physician, the IMG, has got to work for the J1 sponsoring organization for 3 years, specifically in H-1B status. So if the physician gets the waiver and skips out within the first 3-year period of time, except in extenuating circumstances, then if the physician skips out, leaves the sponsoring employer within the 3-year period of time, they violated a key term of the waiver, they become ineligible for permanent residence, and ultimately they're going to have to leave the United States or remain here illegally. Not exactly what you want a physician to do, given the professional stature of a physician. So here's my only point. You certainly want to concentrate on getting the physician a waiver. That opens up the key to letting the physician stay in the United States and opens up a vibrant dialogue that you can have in terms of what are the next steps when you're going to sponsor the physician for permanent residence, if indeed you want to. But the waiver in and of itself builds in a 3-year retention period in which the physician cannot leave unless they face the risk of permanently losing their waiver. So just keep in mind that one of the residual advantages, benefits of a Conrad waiver is this at least limited 3-year retention period. Okay, so we've gone through the waiver. The physician now is locked into the need for H-1B. And so the question burning on everyone's mind is, what is H-1B? How do you get it? And Lon's going to address that.
Thank you, Bob. So the H-1B temporary worker classification is what we have often referred to as the workhorse of the available work visas in the United States. It is the most commonly used work visa by employers to sponsor individuals to work in the United States on a temporary basis. So the beneficiary of a H-1B visa or status is in the United States with non-immigrant intent and for a temporary period of up to 6 years. An individual cannot be in H-1B status beyond the 6-year limit unless they have received sponsorship by an employer through the filing of an immigrant petition at least 365 days before the 6-year limitation, or they have an approved I-140 immigrant petition sponsored by the employer, or that they self-petition before the 6-year limitation. If they do have, or if they meet those two conditions, they can extend their H-1B status beyond the 6-year period. And that, as you know, is very important for certain nationals, specifically nationals from China and India, where there are huge visa backlogs to wait for the opportunity to apply for lawful permanent residence. In sponsoring an individual for H-1B status, as Bob mentioned, someone who gets a J-1 waiver will still need an employer to file the H-1B visa in order for the individual to work in the United States. So that is a second part of obtaining work authorization for a J-1 after they've gotten the waiver. You may also have individuals who come to you already in H-1B status who may now need sponsorship as a physician, and there are certain aspects that you need to also consider when they come to you in H-1B status. We're going to talk about the two types of H-1B sponsorship. There are those that are considered H-1B cap subjects. So a physician may come to you and may be employed with an entity that is considered cap exempt, and I'll talk about the various entities that are cap exempt too. If they come to you and they're in H-1B status, for example, and they have been working for a cap exempt entity and you are not considered a cap exempt entity, you need to make sure there are visa availables, H-1B visa available for you to sponsor the foreign national. And that is what is very difficult about our immigration system, because there are only a limited number of H-1B visas available in the United States. Each year, the government releases 65,000 H-1B numbers plus an additional 20,000 for individuals who have U.S. master's degree. So we have a total pool of 85,000 H-1B visa numbers a year. There are some taken away for another type of H-1B status for nationals of Singapore and Chile called H-1B B1, where they have 6,800 H-1B numbers set aside. If you are a employer who is H-1B subject, meaning you do not fit under the exempt categories that are laid out in the regulations, you have to make sure that there is a H-1B visa number available for you to sponsor a foreign national, or your candidate is someone who has already been counted against the H-1B cap. If not, you need to make sure that you file for their H-1B application by April 1st for the next fiscal year. As you know, each fiscal year starts October 1st. So right now, we are starting to prepare for H-1B petitions for fiscal year 2018, filing for these petitions on April 1st because that's the earliest date that an employer can file but the employment start date won't be until October 1st. It's clear for the last couple of years that the numbers have greatly been under serving the need of U.S. employers. For example, last year we had 236 applications filed in the first week of April.
236,000.
Thank you, Bob. 236,000 applications filed the first week of April in 2016 when there were only 85,000 numbers available. We expect that same amount at minimum to be filed this coming April in 2017. And so as you can see, the demand substantially exceeds the supply. So let's talk about who is exempt from the H-1B cap, because we expect, again, come April, that there will be no H-1B available, H-1B visas available from October 2017 until the next fiscal year starts, because we expect them to all be assigned by the first week of April through the lottery system. So if you have an individual who comes to you and they are currently in H-1B status with an entity that is exempt from the H-1B cap, and you are subject to the H-1B cap, then you need to determine whether there may be other options available through concurrent employment. But those who are usually exempt from the H-1B cap are J-1 waivered physicians. Those who obtain the J-1 waivers that Bob discussed are not subject to the H-1B cap. So if you're able to get a waiver through the various programs that were previously discussed, then you don't need to worry about the H-1B cap. Other entities that are not subject to the H-1B cap are universities and nonprofit institutions that have affiliations or related to the universities. And this is really important because the definition of what is an affiliation or a related entity was recently clarified under the high skilled worker regulations that came out and became effective January 17th. It essentially provided more clarity in terms of what needed to be submitted and replace other policies that were memos by the Immigration Service. So we believe that we're really actually happy about the provision that was passed under the high skilled worker in terms of providing a clarity for what is an affiliated entity. Also, H-1B extensions may not be subject to the cap if they've already been counted towards the cap, or if, as I mentioned previously, you're seeking concurrent employment with someone who is also working for a cap-exempt entity and you're not a cap-exempt entity. There may be other situations that you may also look at in terms of being creative, but essentially if they don't fit under any of these entities, all other require H-1B sponsorship situations will be subject to the H-1B cap. Bob, can you discuss what the importance of making this determination?
Yeah, thanks, Len. Look, you've got two different types of H-1Bs. One can be subject to the cap, one which is not. If it's subject to the cap, chances are you lose control. You subject the case to about a 1 in 3, 1 in 4 chances of being chosen in the lottery. And it also will require you to file the sponsorship papers immediately on April 1. If you're exempt from the cap, the benefit is you can qualify an IMG for H-1B visa status at any time of the year. You're no longer locked into these very tight filing periods. And what I really want to say is just two things. Number one, anytime you get a J-1 waiver for an IMG, based on a Conrad program in particular, they are exempt from the H-1B quota. And once they are exempt from the H-1B quota, they are forever exempt from the H-1B quota. So, for example, if an IMG completes his or her 3 years of H-1B with the J-1 sponsor, wants to move somewhere else and work for a for-profit entity that is normally subject to the cap, by virtue of the fact that the physician had previously gotten a waiver, makes them exempt from the cap forevermore, to quote Edgar Allan Poe. Number two, you gotta give real serious consideration to the applicability of the H-1B cap as you're recruiting an IMG. Because if you're subject to the cap, you've obviously got some major restrictions and major uncertainties, or you might be able to structure the employment relationship in a manner that will result in exemption from the cap. So my only point is, this is one of the real key elements of arranging for immigration, of recruiting an IMG, is to figure out how does the H-1B piece of the puzzle fit into place. Okay, we're running out of time a little bit. We want to just say a couple words about the Grand Ganubi, so to speak, which is how to get permanent residence.
So the most popular options for lawful permanent residence for any U.S. employer is through the filing of a PERM labor certification application with the Department of Labor. The employer has to test the labor market, pay the prevailing wage determined by the Department of Labor, and then the foreign national, if the PERM labor certification is certified by the Department of Labor, will be able to file for lawful permanent resident if a visa number is available and they are eligible. I want to point out that physicians or IMGs who are subject to the 3-year requirement commitment under a Conrad waiver program or any other waiver program cannot apply for adjustment of status, which is the actual green card application, until they've completed the 3-year obligation. So you have to be very strategic about it and make sure that they don't apply earlier than that, because we have seen denials where they have applied earlier than that before their 3-year commitment has ended.
But the employer can take the initial step.
Absolutely.
So it's to tee the case up to make the final application.
Absolutely.
At conclusion.
They can, because the process can take a long time. Most employers do start the process before the 3-year completion and time it where they will be able to apply for the green card. The other option is the national interest waiver for physicians, and under this process, you don't have to file a labor certification with the Department of Labor. You have to document, though, that the foreign national IMG will be committing to an aggregate of 5 years in serving in a medically underserved area or a VA facility. And some IMGs opt for this option because they don't want their employers to have to test the labor market. Again, the filing of the I-45 application has to be very strategic. You can't apply before the 3-year commitment that you have, however, and the application won't be approved until the 5-year commitment, but you can definitely start the process earlier. So those are the 2 basic options that we want to talk about. And Bob, you want to give some final thoughts?
Yeah, that's just some final thoughts. Look, and it kind of goes back to some of my initial thoughts. The key issue obviously becomes, where does an IMG, where does a given candidate fall within your system? And if you've identified an IMG and you want them to work for your organization, then obviously you will need to go through the immigration sponsorship process. And so, yes, it certainly requires some type of substantive understanding of the whole process. But in addition, and under a belief that you're oftentimes in a highly competitive situation, I really think that it makes sense to conceptualize and to address how can you make immigration into part of your recruitment program. And it seems to me that there are a couple key elements. Number one, try to create in advance planning of a game plan, an overall game plan on how to address issues like J1 waivers. What are the H-1B considerations? If possible, what would be the timeline for a sponsorship case for permanent residents? What are the spousal needs, and how do you need to address that in order to encourage retention? What are the expectations? And it seems to me that you need to address those, and in my own opinion, in a highly transparent manner as part of the recruitment negotiations. Number two, putting together the team. Certainly it requires a buy-in by line management. Presumably someone in your HR function will be the key coordinator for the immigration piece. Bringing in immigration counsel who can do the substantive work, the heavy lifting, and making all of those pieces synthesize and work smoothly, and also communicating to the IMG that this is the team that is charged with serving his or her welfare. Number three, it seems to me you should address immigration very forthrightly during the negotiation process, during the recruitment process. Again, this is going to be one of the primary determinants of an IMG's decision on where to commit to professional employment. And number four, you can make immigration, to at least to a certain extent, work for your retention program. That is, the J1 waiver will give you 3 years of employment stability. By virtue of the fact, if you're going to make a commitment to permanent residence, that can add additional periods of time. In particular, a case for permanent residence for a native of India, and India is the largest single provider of IMGs, the whole period of time right now is 9 years. Well, during that whole period of time, the physician will be pretty much committed to working with you. My only point is immigration, it's not just a question of recruitment, it's a question of retention. And the more you know about this area, the better you're able to, and the better you're able to coordinate and manipulate and present all of the aspects of immigration, the more likely you are in terms of recruiting your candidates and creating a program under which they're going to be retained in your organization. So with that, just want to say thank you very much. Really appreciate the invitation extended to us by the Frederickson Healthcare, by David, to present today. And just want to reiterate that the next webinar will take place on March 8th, and it has to do with web accessibility. And I'm sure it's going to be a good program, and hope you come back. Thank you so much.
Thank you.
Bye-bye.